morning. Thank you so much for joining us today for today's Wednesday webinar, Social Security Disability for Epilepsy. Before we go any further, I do want to make a couple of statements. Number one, today's webinar is not meant to be legal advice, but is instead meant to serve as additional background information for individuals who are considering applying for Social Security disability benefits because of their epilepsy. And number two, if you are joining us on the live or watching on the replay, you will find that we do not answer questions on the live, and our responses to questions that may be posted in the comments on the replay are minimal. And the reason for that is not because we don't want to help, but it is because we often need a lot of information to be able to give some semblance of a decent answer to kind of help point you in the right direction or even just answer your question. And I don't like to have you put all of that information out there for others to be able to hear, see, or read. So I do ask if you have questions to kind of keep track of them throughout the webinar. We'll go ahead and right now on the live, put a link in the chat to where you can schedule a call with us. On the replay, that link to schedule a call will be down below. And then on the final slide of today's webinar will be our email, phone number, and we'll drop that link again on the live at the end. So if you do have questions, we do want to help. Please do feel free to reach out to us, but that's why we don't take any questions on the live and why our responses on the replay may be very limited. Here's our roadmap for today. We're going to talk about Social Security disability basics, guidance from the agency, a potential listing, considerations, and then finally how an attorney may be able to help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, and we're a law firm based in Florida where we exclusively practice federal administrative law, and we help clients with their agency level SSDI and SSI matters, sometimes all the way from the initial application through to the appeals council. It depends on the specific situation and the unique circumstances of each case as to when we step in and get involved. It also depends on when clients reach out to us. Here are the basics. There are two Social Security disability programs, SSDI and SSI. SSDI benefits are Social Security disability insurance benefits, and SSI benefits are supplemental security income benefits. Both programs are going to require that you be disabled and unable to work for a period of at least 12 months. Where they differ is SSDI is going to require that you have a sufficient work history. They're going to require that you've paid into the system long enough to be able to take benefits from that system. Typically, we say that you must have worked five of the last 10 years. Sorry, I don't know why I'm talking so fast today. You must have worked 5 of the last 10 years. If you are a younger individual, that may be a little bit different, but by and large, that's kind of our rule of thumb. SSI does not have a work history requirement, but it does require that you have limited income and assets. We don't talk about the income requirement threshold for SSI benefits in the webinar, and that's because it varies depending on household size. Assets is very black and white. If you are single, you cannot have more than $2,000 in assets. If you are married, you cannot have more than $3,000 in assets. Okay, assets do not include one home and one car, but it does include anything above and beyond that. Any property that you own, bank accounts, investment accounts, retirement accounts. If you are married and you each have a car, that second car is going to count towards your assets. Okay. As you see, it is going to require that you be disabled for a period of at least 12 months, but you don't have to wait 12 months before applying for either program. I often say, as soon as you realize that you're going to be out of work for 12 months, go ahead and apply. If that realization comes 8 months into your 12-month period, then apply then. If it comes 3 months into the 12-month period, apply then. As soon as you and your doctors realize, okay, this is going to be at least a year, whether it's through rehab or medication treatment or other types of treatment, or it's a matter of you need to take time away from work to focus on yourself, getting better, things like that. So you don't have to wait for that year to be up before you apply, but it does have to be likely and indicated through the records that you are going to be out of work for at least 12 months due to your impairments. Okay. Here's the 5-step evaluation process for Social Security disability benefits. For both programs, SSDI and SSI, there's kind of a stage 0. And stage 0 is for SSDI. The agency is looking, do you have the work history that's necessary? Have you worked and paid into the system long enough? 5 of the last 10 years, typically. Again, younger individuals, it may be a little bit different, but that's what they're going to look at there, is have you worked and paid into the system long enough? With SSI, they're going to look to make sure that your income and assets are below the required thresholds. So that's step 0, basically. If you don't meet that prong, whether it's the work history requirement for SSDI or the income and asset requirement for SSI, the agency is going to deny your case pretty quickly. They're going to say you don't have the requisite number of credits or your income or assets exceed our threshold. Therefore, you don't qualify for the program you applied for. As long as you meet that secondary prong, the agency will review the file. They're going to first look at, are you currently engaging in substantial gainful activity? In 2023, substantial gainful activity is defined as working more than 20 hours a week or earning more than $1,470 a month. If you are engaging in substantial gainful activity, the agency is going to deny the claim at step 1, saying that you cannot be found disabled under our rules because you are engaging in substantial gainful activity. As long as you're not engaging in substantial gainful activity, the agency, will move to step 2, where they will see, do you have one or more severe medically determinable impairments? They're going to review the medical records, and as long as you have at least one impairment that gives a limitation in your activities of daily living, your work activities, things like that, then you will generally be considered to have that severe medically determinable impairment, and they'll move to step 3. If there's nothing in the medical records that shows that you have a severe impairment that impacts your ability to function on a daily basis, the agency is going to deny the claim at step 2. Okay, step 3 is, do you meet or equal a listing? So they're again going to be reviewing the medical records to see, do you meet or equal one of the listings that's included in the Blue Book? And we'll talk about the epilepsy listing in just a minute. Even if you don't meet or equal that listing, if you have other conditions that are underlying, you may be able to meet or equal another listing. If you don't meet or equal a listing, it's okay. The agency is going to keep moving down through their 5-step evaluation process. If you do meet or equal a listing at stage 3, that's when you'll get that approval letter, okay? So let's say you don't meet or equal a listing, the agency is going to go to step 4. They're going to look at the medical records. They're going to create a residual functional capacity, or an RFC, which is what they believe you are capable of performing on a daily basis despite your condition. At step 4, they're going to use that RFC, your age and your education, to say, okay, can you go back to your past relevant work? Past relevant work is work that you've performed in the last 15 years, long enough to learn the job. If you can go back to one of your past relevant jobs in the last 15 years, the analysis will stop there. The agency will say you are not disabled under our rules because you can go back to work as a blank. Okay. If you cannot go back to your past work, they'll go to step 5, again, using age, RFC, education, past work experience to see, can you engage in any other work? Are there any other jobs in the national economy that an individual with your age, education, work experience, and RFC can perform? If so, you'll get a denial, and they'll say you may not be able to go back to your work, but you can adjust to other work. If you cannot engage in any other work, then that's where you'll get approval at step 5. Here are some considerations, particularly as it relates to epilepsy claims in the disability process. Epilepsy is a pattern of recurrent and unprovoked seizures that are manifestations of abnormal electrical activity in the brain. And there are various types of seizures, from generalized and focal or partial seizures. Social Security evaluates any psychogenic and pseudo seizures under listing section 12. And in adults, the most common potentially disabling seizure types are generalized tonic-clonic and dyscognitive seizures, formerly known as complex partial seizures. Social Security is going to look for at least one detailed description of your seizures from someone, preferably a medical professional, who's observed that type of seizure. If you experience more than one type of seizure, Social Security is going to want to see a description of each type. They don't require EEG results, but if the EEG test results are available in your chart, the agency is going to evaluate them in the context of the other evidence included in your case file. As always, and as I alluded to before, if you don't meet or equal a listing, the agency is going to evaluate whether or not you have the residual functional capacity to engage in substantial gainful activity, whether that's your past work or any other jobs that exist in the national economy. Here's the way the agency counts seizures. It tends to trip people up because it's a little bit differently than what you may be counting seizures as or what your doctors may be counting seizures as. But Social Security is not going to count any seizures prior to 1 month after you begin the prescribed treatment. The required number of seizures that you'll see in the listing in a minute has to occur within the same time period that Social Security is considering in connection with your application, or if you're under a continuing disability review. When evaluating the frequency of your seizures, they do look at adherence to prescribed treatment. So they are going to look to see, are you taking the medication as prescribed? Or when you go see the neurologist, are they saying that you are not taking the medication as prescribed? So here's what are some of the things that the agency does when they're counting seizures. They're going to count multiple seizures that occur within a 24-hour period as just one seizure. The continuous series of seizures without a return to consciousness between seizures, also just one seizure. A dyscognitive seizure that progresses into a generalized tonic-clonic seizure is going to be just one generalized tonic-clonic seizure. Social Security does not tend to count seizures that occur during a period where you're not adhering to the prescribed treatment. So as I said before, it's very important that you do adhere to the prescribed treatment, such as any medications that may be prescribed to you. As I mentioned before, psychogenic non-epileptic seizures and pseudo seizures are not considered under the listing that we're going to cover in a minute, but they're evaluated under Chapter 12 instead. All right, so here's one of the potential listings, the 11.02a, and it's going to require generalized tonic-clonic seizures at least one per month for at least 3 consecutive months, despite adherence to the prescribed treatment. So you'll see it's a pretty high bar to meet. Having one generalized tonic-clonic seizures a quarter is not going to get you to meet listing 11.02a. Okay. 11.02b is for dyscognitive seizures that occur at least once a week, again, for at least 3 consecutive months, despite adherence to the prescribed treatment. So you'll see they require very frequent seizures to meet the listing. Here's 11.02c is going to require generalized tonic-clonic seizures 1 every 2 months for at least 4 consecutive months, despite the adherence to prescribed treatment and a marked limitation in one of the following, whether that's physical functioning, understanding, remembering, or applying information, interacting with others, concentrating, persisting, or maintaining pace, or being able to adapt and manage oneself. Dyscognitive seizures that occur at least once every 2 weeks for at least 3 consecutive months, despite adhering to prescribed treatment. And again, a marked limitation in one of those 5 areas of functioning. So you can see there are generalized tonic-clonic seizures. If they are not happening once a month for every 3 or for at least 3 months, then they're going to look at every other month for at least 4 consecutive months. And the dyscognitive seizures, if they're not happening at least once a week for 3 months, then it's once a week or once every 2 weeks for 3 months. And for those second 2 that are not happening as often, it's going to require a marked limitation in one of the 5 areas of functioning listed in the listing. Okay, so as you'll see, it's a very high bar to meet. We talked about how Social Security counts seizures. So it's important. I typically tell clients to be sure you're keeping track of when the seizures are happening, which you're likely doing already for your neurologist anyways, but to make sure that if you're bringing that calendar to the neurologist to add to your chart, that before you drop it off to them, that you also keep a copy for yourself. Those do not always make it into the electronic charts that get sent to the administration, or even when you request the medical records. So it can be really helpful to just have your own copy of that from the beginning before you give it to the doctor, to just go ahead and keep a copy for yourself. And that way you also have a record of how often they're happening. including sometimes what happens before, what happens during, and what happens after, how long it may take you to return back to your baseline of normal following a seizure. That can be very helpful. And again, as we said before, the agency is going to like to see a description. It's going to need to see, really, a description of what happens before, during, and after the seizure, preferably completed by a medical professional. That's not always possible, but if you've got a family member that can also kind of say what they see you experience before, during, and after, that can be helpful and added to the file as well. Here are some considerations to make. These are general considerations. Medical records are critical. Social Security, they really heavily rely and lean on the medical records, and it's because they view it as a little bit more objective than your statements or a third-party statements who knows you, because often the medical providers don't have an ulterior motive to getting you approved for disability benefits. So that's part of the reason why medical records are so important, particularly objective medical records. If you've had EEGs that do show seizure activity, you're going to want to make sure you remember the clinic or hospital that those were performed in, so that way the agency is able to see a copy of those, because that can also help to not only bolster the claim having an EEG that shows seizure activity, but also there may be a statement from the physician who was perhaps watching or supervising that testing being performed, who may be able to describe what they saw before, during, and after the seizure. Remember, the issue in Social Security disability cases is not just can you go back to your past relevant work, but are there any jobs that exist in the national economy that you can perform? If you are 50 or older, the grid rules might apply, and therefore functional capacity can also be relevant, especially since, as you saw, the listings for epilepsy are a pretty high bar. So oftentimes we get clients that don't meet or equal those listings, and so then we're looking at what their functional capacity is and making that argument that there is no job that exists in the national economy that an individual with their age, education, work experience, and RFC can perform. Again, objective medical records are important. Here's kind of our non-exhaustive list of ways an attorney may be able to help you. We can provide guidance on what correspondence from Social Security actually means. If you are already a client of ours, or you reach out to us with enough time to allow us to file the necessary appeal, we can file necessary appeals. We review your medical records and case file and can sometimes discuss what additional records may be helpful in your case. We review your documents for accuracy and completeness and can discuss what the agency is looking for in those documents. Especially with epilepsy claims, you'll get often kind of the adult function report that the agency is going to want you to fill out about your day-to-day activities. And then there's supplemental questionnaires that come as well to better help them understand what day-to-day life is like for you. And so that's why we don't fill those out, because we, as much as we try to empathize and understand, we don't live it on a daily basis. So we can provide guidance on what they're asking for. We can review it for accuracy and completeness, but we cannot actually answer it for you. We do work with you to provide relevant updates to Social Security throughout your claim, as well as updates from Social Security throughout your claim. If you do have to go for a hearing, we do prepare you for that hearing before an administrative law judge, and then, of course, question you and any witnesses during that hearing, including typically the witnesses that are brought by the agency, including a vocational witness or a medical witness. Okay, here is, as promised, our contact information. If you have questions, please feel free to give us a call, send us an email. If you are watching on the live, we'll go ahead and drop that link again in the chat to schedule a call with us. If you are not watching on the live, but you're watching the replay, that link to schedule a call is going to be down below. You can also give us a call, send us an email. We are always happy to help in any way that we can. And as I've said before, if for some reason we cannot help, we do try to connect you or point you in the right direction of somebody who may be able to. So with all that being said, thank you so much for joining us today. Have a wonderful day.